Hello, my name is Awoegbe Precious Chidinma, currently a 500 level law student of Ebonyi State University, Abakaliki, and a virtual intern at HARLEM Solicitors. Today, I'll be taking you on a lecture titled Overview of Copyright and Copyright Registration in Nigeria. But before that, I'd love you to know what intellectual property is. The World Intellectual Property Organization defined intellectual property to mean the creation of mind, such as inventions, symbols, designs, literary and artistic works, images, and names used in commerce. Intellectual property can also be said to mean any product of human intellect protected by law against unauthorized use by others. What then is intellectual property rights? Intellectual property rights is the right given to persons over the creation of their minds. Types of intellectual property: copyright, patents, trademarks, geographical indications, industrial designs, trade secrets, and so on. For the purpose of today's lecture, I'll be taking you on copyright. What is copyright? Copyright is an exclusive right granted to the originator of a creative work for the work to be reproduced in a limited period of time. World Intellectual Property Organization also defined copyright to mean a legal term used to describe the rights of a creator over their literary and artistic works. In Nigeria, the principal legislation that governs copyright is the Copyright Act of 2004. The Copyright Act of 2004 makes provision for the protection, for the transfer, for the infringement, and the remedies for infringement of copyright. The regulatory agency responsible for the registration and supervising of copyright-related works is the Nigerian Copyright Commission. It is pertinent to note that not all works can be copyrighted, and so Section 1 of the Copyright Act of 2004 laid down the works that can be copyrighted in Nigeria, and they are literary works, musical works, artistic works, cinematograph films, sound recordings, broadcast, computer programs, and softwares. For one's work to be eligible for copyright protection, the following must be established: originality and fixation. Originality in the sense that the work is original, it wasn't gotten or copied from any other person's work, it wasn't gotten from materials in public domain. And fixation in the sense that the work is fixed in a material and permanent form. One's work wouldn't be eligible for protection if it is proved that the making of the work involved an infringement of some other person's work. The infringement of copyright protection was provided for in sections 15 and 16 of the Copyright Act 2004. Section 15 of the Copyright Act 2004 provides for acts that amount to infringement of copyright. It provides that a copyright is infringed where a person, without the authorization or license of the owner, does the following acts: exhibits in public any article in relation of which the copyright is infringed, distributes the article by way of trade, offer for sale, hire. 3. When he has in his possession materials, equipment, plates, tapes, which was used to carry out the infringement. An action for infringement was provided for in Section 16 of the Copyright Act. It provides that an action for infringement of copyright is actionable at the suit of the owner, the assignee, the exclusive holder of the copyright, in the Federal High Court, exercising the jurisdiction where the infringement occurred, and it further provides the reliefs that would be available for the plaintiff in an action or suits for copyright infringement, and they include damages, injunction, accounts, and other reliefs that the court may deem fit to grant in the circumstance. Where it is proved and admitted that an infringement was committed, but that at the time that the infringement was committed, the defendant was not aware or had no reasonable grounds to suspect that copyright exists in the work to which the action relates, the defendant will not be entitled to damages. The plaintiff will not be entitled to damages against the defendant in this circumstance, but be entitled to the account for the profits gotten from the work in relation to the infringement. Registration of copyright. It is pertinent to note that registration of copyright is not a condition precedent for the protection of copyright. That means copyright need not be protected, as the right automatically activates from the time the work is created. However, this registration is advised because it creates certainty for ownership, and it could be used as a prima facie evidence of title in an event of conflicting interests or conflicting rights between two copyright owners, and it could also be used to prevent further infringement in the future or avoid one from copying from you, and so on. The registration of copyright in Nigeria, the process of registration of copyright in Nigeria involves submitting the application for copyright protection at the office of the commissioner, and the application shall be accompanied by 2 copies of the work. One intends to register, an evidence that the prescribed fees has been paid, a completed registration form, and so on. Upon registration, the rights of the license holder are limited to the duration of lifetime of the license holder and 70 years after his death. I hope you find this lecture really educating and helpful. And finally, visit HARLEM Solicitors website, www.harlemsolicitors.com, for more inciting lectures and articles. Also, visit their LinkedIn page, HARLEM Solicitors on LinkedIn, and HARLEM Solicitors on YouTube. Thank you.